All right. Good morning, everybody. So this is part two of the rentals, kind of the rentals overview of rentals from the beginning to the end type of thing. Last week, if you missed it last week we talked a lot about the brokerage agreements, tenant rights, tenant right to represent, also the exclusive right to lease listing agreement, and all the forms that you might need that go into those two parts of the equation. So here today we start off with, okay, we did all of our paperwork, we put the property on the market, we've gotten a bunch of leads because God knows hardly anybody looking for a place to rent has a realtor, so they're all going to call you directly if you're the listing agent. And so you get an application, the application is in, and most of us are going to be using Rent Spree, which you can attach to your Bright MLS listing. So you can they can apply through there. You also when you have a listing, you'll automatically get a link through Rent Spree as well, which you can send to potential tenant applicants if you do show it to them as unrepresented tenants. So you send out the link, they fill out their stuff, and they send you get a notification from Rent Spree that there's an application in. So here's a couple pages. This kind of just gives you an idea of what I do when I'm evaluating a Rent Spree application, to kind of help you guys out and regarding the evaluation of your own listings. But everybody does it a little different. So, but this is just my style. So you get your Rent Spree application, and this kind of looks like a classified document from the Biden administration, but it has the tenant's name on it, prospective tenants, their information on page 1. It also gives you their desired move-in date, how many occupants, whether they have any pets, how many vehicles, all kind of in that little application section. So this is kind of just an overview of the stuff that you're going to be looking at as you proceed through their application. So you kind of can see there's income, there's what their current rent is, that kind of stuff is all listed in here. So as you kind of get into the meat of their application, it kind of reiterates here the person submitting the application, what's their move-in date, gives them their personal information, date of birth, all that kind of stuff. So all that stuff is on here, and like I like to verify this by a lot of times when I get this application in, I don't have the premium version of Rent Spree, but so I normally, once I get an application in, I'll email the person, or if they're unrepresented beforehand, I'll tell them when I showed them the property, if they're going to make application, to send me supporting documentation, like a copy of their driver's license or a copy of their passport, along with proof, their income, verification material, anything else that they think they may need in order to better their position to get this property for rent. So a lot of the times when I'm looking over this stuff, I'm verifying that with that information that they sent me. So their driver's license, that kind of stuff. There is other stuff in here, emergency contact information that you can keep on file if ever needed for later on for the landlord. So it kind of goes through here with all their general information, previous residencies, how much they paid for rent, point of contacts for verifying those rental, previous rental history. That kind of stuff is all listed here. It also goes through who their employer is, how much they make either on a monthly or annual basis, and if they are whether or not they're a W-2 or a 1099 employee. If they're a W-2, you normally can use some pay summaries that they get through their employee every month or every pay period. If they're 1099 employees, then normally it's good to analyze their tax forms, so their Schedule C normally for their business. That way you can see what their profits are, get a better idea of their what they're making. So skipping on through, it also has information, so it has relative information. Normally this isn't really that big of a deal for evaluating, but it is good emergency contact information for later on. If the landlord calls you and says that he's having a hard time getting in touch with the tenants, he's tried their cell phones for several weeks, no one's returning their calls, can you pull the application and see if they had any emergency contact or relatives listed, and you can always give them a ring. Whether or not there's any pets. Now, you know, with pets, right, pets are pets, and ESA are not pets, right? So if someone has a comfort animal or has a service animal, they're not listed normally as pets here. So those are normally questions you might have to ask up front. And then it also has their vehicle information listed. So then you kind of get into the meat of the application here. This one is a good one, right? They have good credit, 750 credit score. But you know, every now and then you're going to see credit scores lower, right? So it's always good to have conversations with your client beforehand, whether or not they have a minimum credit score that they desire. They have requirements. Like a lot of times I have that question during the listing presentation as to what the tenant is looking for an applicant. Like you'll have landlords that don't want an applicant with under a certain credit score, 680, 650, whatever. We're looking for a tenant with whatever their criteria, as long as it doesn't violate fair housing, then you can post it. And a lot of times on those, I'll post it in the agent remarks in MLS. So if the landlord tells me I don't want a credit score 680 or anybody under 680, and I don't want more than 2 incomes to qualify for the property, I'll put that right in the rental application that, you know, or in the MLS listing, in the agent remarks. And I'll also tell unrepresented tenants that when they call. Like you'll get a lot of things through Zillow, Rent Manager, and I'll respond. I'll make a canned email up, because you can make emails up in Zillow, and when they inquire, I'll respond back and said, I've received your inquiry. Thank you for your interest in the property. Just let me know when I could schedule a showing for you. I'm available Saturday from 10 to 2, whatever. Also, FYI, the landlord's criteria for this property is a 680 credit score or above, and no more than 2 incomes to qualify. If that works for you, please email and let me know, and we'll schedule a showing. So half of them I never hear back from, half of them I do. It's a good way to kind of, if you know the criteria, it's a good way to weed out those people that are inquiring through Zillow or other websites to kind of make sure that they're not wasting your time and their money applying for a property that the landlord's not going to consider. And of course, you're always going to get the ones that are on the margin. You know, so be ready for that, right? They're going to say, I have a 670 credit, but I make $200,000. Do you think the landlord would be okay with that? And then, you know, you have to contact and find out and all that kind of stuff. And so, but it's a good way to start. So in this particular case, this person had a 750 credit score, and it also gives you some scoring factors over here to the right in regards to how they came up with that score, or how that score is generated. On the next page, right, it also gives you kind of an overview of how many trade lines they have, credit inquiries, those type of things, and also any derogatory items, negative trade lines and stuff like that. It'll tell you the number of those, 1, 2, 6, 27, whatever. Any fraud indicators will be indicated, and then it gets into the trade summary. This is a good section right here a lot of people don't do anything with this section, but I always like to look this over because it gives me an idea of how much debt this person has. So that way when you're looking at their income and you're looking at the amount of debt they have, they may just barely, say they... But they, what class am I? No, sorry, just kidding. Just messing with you. But it kind of gives you an idea of what the tenant, the prospective tenant's debt to income ratio is, and if they're on the margin and they have a tremendous amount of debt, that could kind of sway your recommendation to the landlord a little bit in regards to that, or at least give the landlord the information that yes, they qualify, a third or less of their income will go to rent. However, they have, X amount of dollars in student debt. They have X amount of dollars in revolving credit. It looks like they have a mortgage somewhere, so they must have a rental property, most likely in another state. And that may or may not have been listed in the prior things, and those are questions that you can ask the prospective tenant, because in that case, if they do have it rented, you could say, well, how much is it rented for? That's additional income, so it could help them out. So it kind of gives you a good overview. Then on the next page, it kind of goes into line by line of their credit, right? So, and like number one is Langley Federal Credit Union. It's an active account, right? So those are two important factors, right? So this is what kind of an account is this? It's and it tells you in here what it is. So this is an automobile loan. So as you can see here, as you're looking down through here, and last reported was, say, February 24, and I'm going to say this report was run somewhere around that time period. So it's an active loan, and it's being paid, it looks like, on time, and it'll kind of give you an idea of their terms for that loan as well, their monthly payment, what's the highest balance that they had when they got it, so that gives you the loan amount, and then if and then there's a little payment summary off to the right that tells you if they've ever been late, whether it's 30, 60, 90, or 120 days. So this kind of gives you an overview of that one account. So you would look at that and say, hey, that account looks like it's in good standing, right? So then you get out to the next one, you're going to do the same evaluation. However, this one is a credit card. So credit card, they have a $4,500 credit limit on it, and the balance is, the highest balance is $3,000, it's close to that as well. But you look down here, they've never been late, 0, 0, 0, 0. So as you're evaluating this, you can see how maybe someone whose credit is maybe lower, you could have blemishes here. And this is the type of information that I set up to give to the landlord, right? So, hey, this is good, right? But say the Wells Fargo one had, 2 30-day lates, 1 90-day late. I would let in a summary that I do to the landlord, I would let them know that, hey, they do have all these accounts. However, on one of their accounts, they were twice 30 days late and once 90 days late. The most recent late payment was a year ago. So maybe they had a hardship in their life. Who knows what happened during that little time frame, and they were a little late with the payment, and it got recorded. But it's just information. I try to just provide the information to my landlord and let them kind of decide and dissolve what they want to do with the information. So kind of cruising through here, they have other active, and then as you kind of go through, here, you'll see number 4 is Langley Federal Credit Union as well, but that account is closed. So you can still look it over. It's of less interest to me when they're closed, because they don't count against their credit limits and their available credit and all that kind of stuff. But it does give you an idea if they have an account and maybe there's some late payments in there, and you can get an idea of when those late payments are. And when they're 2, 3, 4, 5 years removed, I mean, they become less and less weighted the further away they are. So that's how I kind of go through it. And I may in those instances let the, in my summary to the landlord write in the in the email that this particular tenant had some 30-day or 60-day lates, but they're over 5 years ago, and those accounts have closed, and it looks like they've rebuilt their credit. Next page on here. Next part of it, after you kind of look through all their credit lines, gets into their any criminal record, criminal activity. This probably wasn't the best one to pull because this one has no criminal activity. Most of the time what you're going to see is vehicle moving violations. I see a lot of traffic speeding or reckless driving because they were over 15 miles over the speed limit or stuff like that. Those normally, depending on how long ago they were, they vary on the level that you want to put weight into them. Once again, I still let the landlord know that their criminal background came back with a couple speeding tickets. The last one was 3 years ago, and that's all I pretty much say about it. Now, when you get into more serious offenses, of course, the more recent offenses are going to be flags, right? So, like, assault with a deadly weapon. There's a myriad of things that could show up in here, right? And so, it really, when you're evaluating this, you really have to kind of look at it in kind of two parts. Yes, it's an issue, right? Yes, I need to let the landlord know about it. However, this person was 18 years old, and it was 15 years ago. Nothing has happened since then. It's 15 years old, right? We all were 18 at one point in our lives, right? We did crazy stuff, right? So when you're evaluating this, you have to kind of put perspective into it when you're informing the landlord. Yeah, there's some criminal activity that happened here when this person was 18. This person's now 32. There has been nothing in their record here, not even a traffic ticket since this incident happened when they were 18. I would say it appears they learned their lesson back then. So I would not use that as a blemish on this applicant. Now, you might find in here a bunch of DUIs, right? I mean, in recent. And then that could be a blemish, right? Your landlord, and now this person is I'm just going to say, this person's an Amazon driver. That's his income. He works for Amazon. He's a driver, or she's a driver. And they had a DUI less than a year ago. And it says in here it hasn't gone to court yet, so it's not adjudicated. Well, if that person gets their license taken away, that would mean that they're not going to have money for rent, right? So that could sway your opinion of this person's application based on what you might see here in criminal activity. Another section here also is their eviction record. It'll give you an idea if there's been any reported evictions. Now, this doesn't mean all evictions are going to be in here. It's only reported evictions, right? I mean, if you're my tenant and I tell you to get out because you haven't paid the rent and I don't have to take you to court, theoretically that's an eviction, but you left voluntarily, so I didn't have to go to court and file and all that kind of stuff. So it's only recorded evictions that are court adjudicated, right? So those will be listed here. And of course, anytime you see that, it's going to be a red flag for you. And of course, as time elapses, they become, it's 10 years ago, 15 years ago, 20 years ago. The 20 years ago, even though it's recorded, we live in a society today where it's hard to hold someone accountable for something that happened 20 years ago. Once again, they could have been 22 years old, they could have lost their job, they couldn't find another job, the economy, there's a lot of mitigating circumstances. So just be careful when you're looking this over and kind of put time on it to kind of help you weigh what your opinion of that person is going to be as you're making your summary recommendation to the landlord. Then I take all that information and I put it into like a little spreadsheet. So I kind of do this spreadsheet thing before I start evaluating through the application. So I make this out, and as I'm going through, I write the information down. So, you know, they want a 1-year lease, their move-in date is here, they have 3 occupants. Now, on this one, there was another application too, and I wrote a big question mark because one rental application said 3 applicants, another application said 2 applicants, I forget how it was. So I put a question mark there because I wanted to verify if we did accept them, I wanted to verify the number of occupants. And then no pets. And then I take their information here and I kind of, if this one's only 2, so I did their names with their initials and then kind of go through and I write what I find in their credit, in their application. So I'll just stick with the one on the left here. They had a 750 credit score. They had an auto loan for $25,000. Their monthly payment was $596. They had credit card debt in the amount of $81. Very few trade lines, so only 4 trade lines in that credit report. And then what they do, what their monthly income is, how long they've been doing it. So this one particular one was the owner. They own their own pool company, and they just started it, say, last year in August, and that's what they're reporting as their monthly pay. Rental history, I like to write it down, especially when you have multiple applications, because sometimes they're living together, sometimes they're not, sometimes they're living in separate places and they're going to cohabitate. So if they're living together, that's fine. However, if they're living apart, now you have to do verification on 2 different properties, right? So I'll write down what their monthly rent is, whether, where they live, that kind of stuff, any criminal eviction, and then at the bottom I do like an income to ratio. Like once I can verify their income, I'll say, okay, they make $10,000 a month, or $150,000 a year. Their rent is $2,000 a month times 12. That's $24,000 a month, and then I'll do a ratio. And if that number is 33% or lower, I look at them as a qualified candidate. If it looks like they're applying, I'm going to say the rent is $4,000 a month, so they're looking at $48,000 a year for rent, and they make $90,000 or $100,000. That's almost half of their income is going to be paid towards rent. So normally the formula is you want that number to be 33% or lower. But I mean, if they have good credit, I mean, it's kind of a mixing bowl, right? So I mean, if they have 750 to 800 credit scores, they make $120,000 a year. Maybe the husband works, the wife doesn't, or the wife works and the husband doesn't. Whatever the scenario is, they have very limited credit card debt and very limited debt showing on their credit report. I mean, it looks like they managed well with what they have. So you could take an applicant who is above that 33%, yet their credit is good, their debt is low. So there's no real set staple to say yes, no. All you can do is put the information out and go to the landlord and say, hey, here's what I've got. And kind of, hey, I mean, and then converse about it. May have a conversation regarding it. Any questions on that process? We'll start off in the back and work our way forward. How's that sound? That would be you. Hold on.
Thank you very much for all information. I have a question. When you get the application, it seems good, and you get a phone call from the other people are interested, want to fill up the application, what do you suggest? Should we tell them we got an application, wait until what happened, or tell everybody fill up the application?
I'm not sure I'm following you.
Do you keep taking applications if you have a good one, or do you
Oh.
let them know we're probably going to accept this one?
Well, I mean, it's your own personal decision. I mean, of course, the landlord wants the best qualified applicant, right? The other part of the equation is I would never turn someone down. If we don't have a signed lease yet, I would never turn someone down, but I would tell them that we have an application in, and it looks good. However, we don't have a signed lease yet. I'm more than willing to show you the property and you can start the process, but you might want to hold off on, it's X amount of dollars to apply. You might want to hold off on doing that until we have a better idea of whether or not this lease is going to stick or not. Because I can't tell you how many times we've approved an applicant and before the lease is signed, they pull out. So that potential applicant over here that you just told not to apply, that might have been the application. So I would never flat out tell someone not to apply. I would just let them know there's another application. It's in review. It currently looks good. However, we don't have a signed lease. And then I've had people that'll say they want to see it, and they'll go look at it and they'll make application, and they'll make application and they'll offer $100 more a month, or $200 more a month, or a 2-year lease, or something of that nature that they feel that might sway the landlord to take someone else's application. But until the lease is signed, the landlord or the tenant have the right to dissolve the relationship. So hopefully that answers your question.
Thank you. Yes.
Thank you, Steve. Steve, what kind of the verifications for these prospective tenants do you recommend? Like the employer or the prior where they have been living, or any personal references to check? Do you make a call to them? What do you do?
On verification of income, it depends. If they're a government employee and they provide me with government, you learn over the years that there's certain employers that you're not going to get information from them.
Sure.
So like if they're a State Department, government, military, and they provide you with their statement from their employee, authentic statement, and you can verify that. You can also look online. Like military people are very easy to look at because their pay is on the internet. So you can look at a chart. If you know their rank, which they might put in their application, you can look up and see how much money they make, how much is their allowance for housing. All that stuff is published information out there. But when you get into other companies, it depends. If they work for a company that is secure, then you may not get that information. So I'll take whatever pay stub they can give me. I'll try and call their boss, but I won't hold up the application based on the fact that I can't get in touch with someone. Then there's a lot of companies that use a employment verification service that you have to put in a written request to get the information through this third-party provider. It could take anywhere up to 3 to 5 days to get that information. It depends. If you have someone on the margin in regards to your rental application process, and you want to make sure that what they're telling you is correct, then I would wait that 3 to 5 days. If they've got a 750 credit score and they've given me pay summaries, and I called the number on there and their boss says they work there. However, in order to get that information, I got to go to a third-party website and it's going to take 3 to 5 days. I may document that on my sheet, and when I call the landlord, I could say, hey, do you want me to check this further? We've got a pay stub. I talked to their boss. They said they work there. However, I can't verify these numbers unless I put it in this request. They may say, no, it looks good to me. I'm good to go with what you got. But when you get down to people that are W-2, or not W-2, 1099 employees or own their own company, you got to spend a lot of time drudging through their tax forms to get an idea of how much money they make, so that you can get an idea how they can pay their rent. So those are a little bit more challenging, and tenants sometimes are not willing to give you the tax forms that you need in order to verify. If they don't give you the info, then I would say it's a, depending on what their credit score is, how that is, it'll all play out. The other part of it is rental history. I always call rental history. I think it's more important on rental history than some of this other stuff we're talking about.
Yeah.
If you talk, and you have to look for hidden clues when you're talking to someone about someone regarding a rental. So, because they want it, if the relationship went bad, they don't want that person to stay any longer than they've been there. They want them out. So they're not going to be like forthcoming and say that person's horrible, that person never, that person this, that person that. They're going to say, oh, and you have to look for like key words, and then I always ask, would you re-rent the property to them?
Got it.
And that normally, no, I wouldn't. And I really don't care to discuss why.
Mm-hmm.
Okay? I understand what you're telling me, right? But it also works the other way. Like I did a rental verification on someone one time, and I talked to their previous property management company, and they didn't have very good things to say about these tenants. Very needy, very, complained all the time, did this, did that, did this. I mean, for 10 minutes of a conversation, other than paying the rent on time, and they were horrible tenants. I was like, oh my God, right? So I presented it to the landlord, and I presented it in a way that they would say, no, thank you. And they said, okay, they sound good to us. I was like, oh my God. Oh my God, right? I was doing property management. I was the property manager too for this property. And I was like, oh my God, this is going to be horrible. These were the nicest people ever. They were so nice. Like they were tenants for like 3 years. And like we developed this relationship, and we would talk. And I said, I'm just going to let you know, when I checked on your rental verification, when I talked to your previous property management company, you guys are very nice. And I haven't had any issues, but they said, they had some issues with you guys. And they were like, oh, they're the worst property management company ever. They were horrible. They didn't do anything. We had this issue forever, that issue forever. So, I mean, it's kind of a double-edged sword, right? So you don't know what you're going to get. So you have to kind of look subjectively, like, right? So I mean, it's something that happened to me. Like I had the impression, I don't want these people. I got to manage this property. I don't want these people. They're going to be horrible. And they ended up being very nice people. So you have to kind of keep your thought pattern sometimes in check, and things turn out differently. So
Thank you.
Hold on, question back there, and then we'll come up to CC.
Along those same lines, in the old paper application, there was a section that the applicant had to sign authorizing release of certain information that you could then send to HR if there is HR verification for jobs,
right,
or also property management. A lot of these companies will not release the information unless you send them that.
Yes.
How do you do that with rent spree? There is nothing that I'm aware of where you can take a part of the application and send it to them saying, I have authorization for you to release this information.
Right. The twist of that, right, is I would throw it, and what I've done a couple times, I've thrown it back to the prospective tenant. I would say, hey, you need to contact your employer, and have them release this information to us. Here's my email address. Here's my information. Call them as soon as possible and have that information released. Some of these companies charge. There's a company called The Work Number. If you've ever had to deal with them as rentals, they're called The Work Number. They do a lot of employee verifications for a lot of different companies. So I'll just tell, and they charge a fee. So whatever that fee is, right? So I'll just tell, I used to absorb it as part of the process. I'm like, hell with that, I'm not doing that anymore. So if I have to get information through a third-party vendor, I throw it back on the tenant, and I say, hey, you need to contact these people and have them release this information to us. And I would make up a sheet, that says, you need to verify their gross annual salary, time, number of how long they've worked for them, what their position is, blah, 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 and then they'll get you that information. CC, hold on. Oh, a follow-on?
Yeah, actually, just real quick, I already know the answer to this, but I wanted to ask because I get the question a lot. Does order of application matter?
Not really. I mean, that's the old way. The old way used to be first in, first out, right? So, and a lot of times I kind of go off of that same strategy. However, on the weekends, like if you get 3 applications in over the weekend, when they were paper and they sent a check in for the application fee, it was a lot easier to say, hey, application number 1 and 2, we may go with we've got 3 applications. Do you want us to run your stuff at the same time as all these others, or do you want us to wait? But now in Rent Spree, when they put their information in, it's charged right away. So they get charged the fee. Right. So I just review them as they come in. They're paying, so I review them. I mean, if I'm in the process of reviewing one and another one comes in that it looks like a better fit applicant or whatever, I'm not going to let it just sit there. I'm going to make sure that I process it and provide the information to the landlord. It's ultimately their decision, right? Yes, CC.
Now, 2 questions. First of all, the application that you smudge out their names. Now, when you provide it landlord, you don't provide what their full names, do you?
No.
Okay. Next is that ratio. I usually taught by.
So hold on a second. So what she's saying is so when you're talking to your landlords about prospective tenants, you're to cover yourself in fair housing, right? Make sure that I don't give the names of the tenants. I'll say, applicant number 1, applicant number 2. Applicant number 1 is, 2 people. They appear to be married. They have the same last name, blah, blah, blah. Applicants number 2, 5 people, whatever, and go through them and try not to divulge information where they could make a decision on the application that would violate fair housing. I also don't provide a copy of this application to the landlord.
Right.
If the landlord requests it, if they accept an application, I would never provide applications until they have selected an applicant. If they've selected an applicant and they process it and a lease is signed and they say, hey, Steve, you're not managing the property, we would like a copy of the application, I would say, let me ask the tenants. I would ask the tenants, and I would get an email response from them. Yes, it's okay to provide the landlord, a copy of our application, and then I would save that email, and then I would provide that copy. I wouldn't provide copies of the Rent Spree application to the landlord unless I had some sort of direction that approved from the tenants.
That's why I brought it out, because I've been taught that way.
Yep.
And second one, I do go by ratio, qualifying ratio.
Yep.
1 month's rent times 40 is their minimum income. Is that too high?
I don't know. I've never done that. So
Because
right. Yeah.
4 times.
I do the ratio where I take the annual salary and divide it by or the other way around, the annual rent divided by the salary. And then it'll give you a percentage. If that number is 33% or lower, then they've qualified via income.
The reason I do that because I was previously, big company I was with,
Yeah.
that's how they have us do it.
Right.
And that's why I do.
Right.
Every time I interview first
Right.
their income when they come in as a requiring touring the house, then I need a talk before they lose their application fee. They instantly gonna lose it. Therefore, I always go over with it
Yeah.
before I even give them tour.
Right.
So all these things is very important. A lot of times that I have seen people got their application just dump onto their landlord.
Oh,
I
yeah,
think
yeah. There's
that is a very dangerous thing. So I brought
It
out
is.
because in the class, so nobody can get in trouble. That's all.
Right. Yeah, no. I mean, I mean, I've heard numbers as high as 40% of the you know, like say your annual, you know, your annual income is $100,000, and I've heard, you know, you could take 40% of that, and as long as that 40% ratio worked out, that's the level that you could look at. But I like the third. It's easier to remember, easier to work by. 1/3 of your gross annual salary is approximately the number you don't want to go over with in regards to your gross annual rent. So, sir.
Isn't the application automatically a part of the lease? Or it
No.
becomes part of the lease?
No.
So
Nope. No, it's not. It doesn't become part of the lease. However, there is language in the lease that says that the information that the applicant provided is truthful, and that if it's not, then that could be a breach of the lease.
So who would be the judge then if the landlord doesn't have a copy of the application?
Well, that's why we're required to keep a copy of everything for 3 years, as per DPOR regulations, right?
Okay.
So we are being hired by the landlord and entrusted by the public to hold these applications, and all supporting documentation, right? So if the landlord, I mean, I've had landlords ask for the copy of the application. These ones not so bad because a lot of the pertinent information is X'd out, like Social Security number. But in a day and age of such high fraud, I would be very leery about giving, I mean, driver's license information's all in here, all kinds of information in here about this person. If it got in the wrong hands, could potentially cause some pain and suffering for that tenant. So unless it's, the rent spree application link is provided by us, Samson Properties, to the potential tenant. They fill out the application, and that information is coming to us, and we're thought to be keeping it in good faith and in good protection. If we're providing that without their knowledge to the landlord, yes, the landlord is a person that is taking the property. There's nothing wrong with providing these documents to the landlord. You just need to get that tenant's permission. That absolves you as a real estate agent from anything down the road later on that tenant says, my information somehow got out there, someone stole my information, I think it was you. Well, yeah, I turned it over to the landlord because you said it was okay. But all my files are locked up, and no one took my stuff. I mean, a lot of stuff we do in real estate is cover your ass, right? So make sure that you cover it. And to do that, if you're providing rental applications, I'm just going to give you a scenario. You're providing a rental application to your landlord. Your landlord says, no, thank you, I don't want this one. You get another one, you send it over. No, thank you, I don't want this one. Then they get one, John Smith, they take that one. They were all pretty good, but they took this one, John Smith. These names they couldn't recognize. These people file fair housing, right? They file a fair housing complaint against you and the landlord. And they say, you sent my application to the landlord and he didn't take me because of my last name. That $14,000 lighter in your wallet is going to hurt, right? I think that's the minimum fee or minimum fine. So, I mean, I would be very careful. I mean, believe it or not, rental applications, rentals, they're the least amount of money and the highest liability as agents. So I would, if you're going to be a rental leasing agent, be careful. Be very careful.
At what point in time do you request the earnest deposit check from the applicant?
Well, it's all outlined in the lease now, right? Before when we had paper, right, we used to ask for the $50 or $45 application fee and and the deposit made payable to Samson Properties, whatever company you worked for. Now, in the electronic age, this stuff is all done electronically now, so they make application. So now it's outlined in the lease when that money is due, right? So we'll talk briefly about that when we get to the lease.
Okay. Thank you.
Anyone else on this wonderful subject?
No, I had a different subject.
And this isn't even the hard one yet. Hold on. Go ahead. Did you have a question?
But I had a different subject.
Oh, okay. All right. So other forms that you might need in reviewing. Did I miss a couple things? I may have. If I did, I apologize. But other forms that you may need, and maybe these are later on in your thing. Maybe I put them out of whack, or I missed them. May have missed them. Yeah. Well, sorry about that. But this one, it's not in there, because I'm using the same one you guys are. But this one, so other forms you might need during the application process, right? As I said, what we were just talking about is the easy stuff. Here now we're talking about accommodations for that someone might need to make for reasonable accommodations, maybe someone who's handicapped or something of that nature, right? So they have to make alterations or something like that to the property in order to enjoy it. So they may, during their application process, provide this form, which tells the landlord that there's accommodations that person may need to make to the property and what those things are. So just be aware that that could potentially be out there. And also, if their disability is not readily, you're not readily able to know what that disability is, you can ask for verification of it. So this would be a document that we would put together as a tenant, because they're asking for, say, something, some sort of modification, and say they're unrepresented, and we met them at the property and they didn't seem to have any, disability that we could see. We could ask for verification of that disability by providing this document to them. So they would verify what their disability is, and they would tell us once again what requested modifications that they would need to the property. Now, any modifications that are normally done to the property from someone with a disability are normally put back to the way that they were in most cases after they depart. Yeah. You have to wait till you get the mic. Otherwise, there's a $50 fine.
Okay. If
Payable in cash.
I will collect that.
okay, can you hear me? Yes. If applicants say I have service animal, do we ask?
You're getting ahead of me.
Do
You're
we
getting
ask
ahead of
them
me.
to send the proof for that?
Now $100.
No.
So, all right, the next one is assisted animal notice. Okay? So this one is if the person who is applying has an assisted animal that needs to be approved, right, for any reason. So they would submit this document. It's an NVAR form called Assisted Animal Notice, and it's a request for reasonable accommodations from the applicant to the landlord. And so the landlord would look at that and decide whether or not, and now we're talking, this is for assisted animal notice, right? So this is someone who needs an animal to help them get through their life, not comfort animals. We're not talking comfort animals here. We're talking more on the service animal lineup here. So if they need to have that animal with them, then this would be the form that they would send in there, and then it would get checked whether or not they're approved and denied. And if they're denied for whatever reason prior to a lease being drafted, it would put in there what that was for. So when you get into you have to be very leery too, right? So remember, pets, ESAs, and comfort animals are all different. right? Pets are pets. Emotional support animals and service animals are not pets. They have a purpose, okay? The problem as a listing agent, you're going to find that a lot of properties that say I have a property that I have for rent and it says pets case by case or no pets. I get an application. Nowhere in that rental application that we just saw did it say anything about pets or animals, assisted animals, or any type of animal whatsoever. So here's normally what happens. I get an application in. I process it. I contact you as the tenant and I say, hey, your application looks good. The landlord has approved your application. 24 hours later, I get an email or a call from you and says, hey, I forgot to tell you, I got 2 small ESA dogs, or I got 2 comfort dogs. Here's my proof. Here's my documents. I forgot to put that in my application. Right. So you've just approved them. So now you call the landlord back and you say, hey, landlord, I'm sending the lease over here, but I just found out that the tenants have 2 emotional support dogs. Well, I don't want 2 dogs. Well, you don't have a choice. What do you mean I don't have a choice? You have to take them because of fair housing, right? The American Disability Act says that if you deny an application based on this requirement, you could be in violation of the American Disability Act. Landlord says, I don't care what violation I'm in. I don't want them, right? I don't want any dogs in my. I was willing to take 1 cat, but that's it. Well, you unfortunately don't have the choice, unless you take the property off the market. You can decide, okay, I don't want to rent it anymore. I'm taking it off the market. I pull it off the MLS, and you go about your day. But your landlord has to be ready for that. You have to prep your landlord for this. I had clients one time. One's a doctor, the other's an attorney. And we had no pets. And the tenant moved in. 6 months later, she called and said, hey, I need to get an emotional support animal. I'm getting a dog. I said, what? There's no pets. She said, Steve, are you familiar with the Americans with Disability Act? I said, yeah, somewhat. She's like, I need to get an emotional support animal, and I'm picking a dog. Well, I called the landlords up and I said, hey, your tenant's going to get a dog. Are you okay with that? Well, no, I'm not okay with that. I said, well, according to the American Disability Act, of course, by then I did all my research. I had all the links. I had all the information. I sent it all to them and I said, hey, here's everything. No, you have to tell her no. We want a $1,000 pet deposit. You can't charge a pet deposit. What do you mean I can't charge a pet deposit? So we got it after the fact, but most of the time you're going to see this during the application process. How can you avoid this kind of stuff? Or how can you get to a point where you can alleviate this, right? It's hard because it puts you in a position where you have to ask questions. Hey, is your application complete? Because there's an argument that says if you don't note in your application that you have emotional support or service animals in your application, there's a paragraph in the lease that says truth in application, right? Well, were they truthful in their application? Maybe not, but now what are you going to do about it, right? Now if you boot them out or you cancel their lease, now there's a potential lawsuit for you from American Disability Act. So there's ways to look, right? How can you do it? Facebook, social media, LinkedIn, other places. Why? People love to post pictures of them with their dog, their cat, their animals, right? You can find out a lot of stuff about people before you accept an application by perusing social media for that person. Look at what they have, okay? I've had a couple where I peruse social media and they've had, I see a lot of pictures with a dog. So I'll say, hey, we've reviewed your application, blah, blah, blah. We've had everything here, but hey, we did a social media peruse of your accounts and we noticed that you have a dog. We don't have the dog. The dog died 6 months ago. Okay, well, sorry for bringing that up. We're just doing our due diligence over here. It wasn't noted on your application, and we're good to go. So you're not planning on bringing any pets in the property? Nope, we're good. Okay. So social media can help you in processing rental applications. So use all the different resources that you can in order to try and verify this stuff. But of course, nothing is 100% foolproof. I guarantee you, if you're doing rental listings, you're going to get this happen to you one of these times where you're going to approve an application, and after it's approved, you're going to get a call or an email from the prospective tenant telling you that they have emotional support animals. Be ready with your landlord for that conversation. How? Have that conversation beforehand with that landlord. Hey, I know you said no pets, but I want you to understand that we're required by the American Disability Act, if someone comes in with an emotional support animal or a dog or a service animal, that you can't say no. If they qualify for everything else, good income, verified employment, verified rental history, they meet the ratios, you can't say no based on a service animal or emotional support animal. So make sure your landlord is prepared for that conversation. Otherwise, they shouldn't be a landlord, right? So any questions on that particular part? None, I'm sure.
Hello, Steve. How about renewal? Can we deny the renewal?
Well, if they pay their rent on their time, and you're going to re-rent the property, and they haven't been a problem, and you ask them to leave after 1 year because they came in with an emotional support animal, I would tell your landlord to be ready for a lawsuit. So the reason being is, I mean, even if you're raising the rent, okay, hey, we're going to raise the rent $200. That's different. If I come to you and say, hey, you know, we don't want you anyways, but hey, we're raising the rent $500 a month, starting at the end of your lease, and I say yes, that's fine. Well, you're going to move me out to renovate the property, okay? Well, you better not list it in 30 days and not have renovations done. So that would be my take is, if you're going to move someone out to do stuff to the property, that's different. But if you're going to move someone out because once they're in there with a pet, who the heck cares, right? I mean, if you work with people, like the situation I was just talking about earlier with the emotional support animal, where we were in the lease, and they said, hey, we're going to get I need to get an emotional support animal. She actually worked with us. We couldn't charge we couldn't charge a pet deposit, that kind of stuff. But we asked her, hey, can you? The reason why the landlords were adamant against it is because they had a lot of hardwood floors in the property. So we asked the tenant, could you cover up the hardwood floors as best as possible to mitigate any damage from your emotional support animal, which she did. However, that dog chewed the crap out of that hardwood floors. But when she moved out, she had all the hardwood floors refinished, and before we did her rental checkout, it was all done and looked spectacular when she left. So there's a lot of good tenants out there. Any other questions back there before I go really quick through the lease?
Okay, hi, Steve. So this is not for emotional pet question, but for pets. So if they have 4 cats, 1 doggy, what is the limit, or it?
There's no criteria.
And the amount of money for the deposit of those animals.
The only requirement on money, okay, so like if I did a rental application one time, I swear they had a farm, right? I was like, holy shit, these people should be renting. They should be buying, right? These people shouldn't be these shouldn't be tenants, right? So I was like, oh my God, like they have like 3 dogs, 2 cats, a guinea pig, 3 gold, it was like, oh my God, they got more pets than kids, right? And my landlord was like, I don't want all that, right, in my house, right? And so we just went back and said, hey, we're not, my clients aren't interested, right? So that's why most of the time on most of the listings that I do, if they're interested in, if they're okay with pets, then I'm going to put pets case by case. Why? Because now you have the luxury of going back to the landlord and see if they're okay with whatever request you're getting. But yeah, some people out there are traveling with a farm, right? So who the heck wants all that in their house, right? I got a German Shepherd, I got a Pit Bull, I got this, I got that. It's like, oh my God. How about we go out and look at a couple properties for sale? I could find you one over here instead of this rental because they're not going to take you, right? So, and then as far as pet deposit, the only requirement in pet deposit is a VRLTA says that you can't charge a tenant more than 2 months rent total. That includes a pet deposit. Security deposit, pet deposit is all incorporated. So if you're charging a tenant, say a tenant has bad credit and you're charging them a 2-month security deposit, then you can't charge, you're not supposed to charge additional pet deposit, right? Because you've already got 2 months rent. So the VRLTA says that the maximum amount you can charge someone for security deposit / pet deposit towards any deposits is 2 months rent. So if you have a tenant that's moving in with 2 cats, 3 dogs, and a partridge in a pear tree, and you want to charge, and it's a $3,000 a month rental, you're charging them $3,000 for their security deposit, you could charge them another $3,000 for their pet deposit. Or you could charge them $2,000 or $1,000. There's no number associated with that. As long as you're not charging more than 2 months rent, total amount as deposits.
Steve, just FYI, aside from a landlord putting restrictions on pets, various jurisdictions, specifically Fairfax County, does have limits on the number of dogs, et cetera, that you can have based on the square footage of the lot. Yep. So you can, if you need to, you can bring that into account.
Right. And a lot of condominiums have pet restrictions as well. So weights, size, breeds, all that kind of stuff.
Okay, in that case, I just want to go back. Size of rooms, occupancy. Most of the people, you have 3 bedrooms, they think they can have 2 for each room. I thought, I mentioned this long before too. I went to class and learned, and also several years back, they announced statewide, you have to, in order to share the room for 2 people, each have to have 50 square foot. Therefore, you have to have a 10 by 10 room sizes. If less than that, you can refuse to have a 2 people occupancy. Okay. That was in the Virginia regulation. And also, I want to ask you another question about going back. When no reason you can not renew a tenant if you have a bad behavior, pay on time, bad behavior, you no longer want to suffer through that behavior, you can still not renew the tenant.
Yeah, that's not fair housing.
Right.
Bad behavior is not fair housing.
Right. That's all.
But yeah, earlier we were just talking about if someone had ESA, emotional support animals or service animals, and you wanted them out after a year, and they, you didn't have any problem with them, and then you said, I'm not renewing your lease, and they move out, and then you re-rent it, you could potentially have an issue. But no, I mean, if you have a bad relationship with a tenant for whatever reason, and you're the landlord, or the landlord has a bad relationship with the tenant, you don't have to offer them renewal.
Right. So I don't want any landlord to be scared stiff out of it.
Yeah. All right. So the next on the docket is the VRLTA lease, and we're just going to hit parts of this as we kind of zip through here to kind of finish up at 10:30 or 11:30. But oh man, I'm super fast. So here is your VRLTA lease. This is the one that most of us are going to use here in Virginia, Northern Virginia. If you're down in the Richmond area, down there is a VAR lease that you could use. But this is a pretty strong lease. I would highly recommend whenever you have the availability to use it. So most of this section, top part, is pretty self-explanatory. Then you get into the lease terms. So here you're going to deliver possession of the premises to the tenant on and whatever that time may be. You can put whatever time, AM, PM. Most of the time when I'm filling this in, I do 12 PM, so like 12 o'clock PM, noon, on whatever the start date is. Tenant will vacate the premises no later than, and I normally use 5 PM as a lease end time, but that's me. You could do whatever is more convenient to you. And then to make sure that all parties understand that this is not an automatic renewing lease. So this lease expires. If neither party does anything, then at the end of the lease term, the tenant is expecting to move out. So if your landlord allows this to go without a lease, right? Theoretically, they don't have a lease, right? So they have to now give 60 days notice. Once they miss this date and the tenant stays in and they accept rent, now it turns into a different type of lease, and they have to provide 60 days notice in order to get that tenant out, or vice versa. If the tenant wants to leave, they have to provide 60 days notice. How do I get next? And then down here is a notice. This is new to this lease, right? Now you can provide the contact information for both the landlord and the tenant in the lease, and then how they want to receive communications back and forth. I would say 99.9% of the leases are checking the box electronic delivery, which means you can communicate back and forth notices with the tenant via email. That would be considered electronic delivery. Now, this was the section that I was talking about a little while ago when someone had asked a question in regards to when is the security deposit due. It depends on what you put in here on paragraph 4. So in this case, right, you have the first full month rent. So payable in certified funds, cashier's check, money order, or bank wired funds. Normally, this is the money that we will take in as the listing company to pay any commissions, pay ourselves, and then whatever's left goes to the landlord. So we're going to put whatever that amount is, and normally we want 1 month's rent, so that would be a full month's rent, and it's due me. I write in there upon lease signing, upon signing of the lease, right? So when the tenant signs the lease, I'm expecting that money to be transferred or provided, and it's going to come to the listing brokerage, right? Unless you're working with a property management company, and then you would check the property management. Or if your landlord sometimes the landlord wants all the money and then they want to cut a check to Samson, which is perfectly fine as well. So you could check landlord, and then the landlord somewhere along the line will pay Samson whatever their fee is. If there's any prorated amount, you would fill that section in. Then you would fill in the monthly rent installments. So your monthly rent would be whatever, when that's due, normally on the first of the month. And then who gets that money? Well, landlord, management. Security deposit, as outlined in paragraph 5, how much is that security deposit? Whatever that number is. When it's due, normally if I have the first full month's rent due upon lease signing, then I have the security deposit due upon move-in. So I would put in their due date, move-in, whatever that date is. So if it's April 1st, I would write April 1st. April 5th, September 1st, whatever that date is. And that's payable to the landlord. And then if there's any pet deposits or non-refundable pet fees, if anything, and any other fees that there may be. Condo has a move-in fee, or there's different fees, a pool fee at a HOA that you have to pay. Those fees should be paid or outlined here so that the tenant understands what fee they have to pay in order to have enjoyment of the property. So all pretty self-explanatory. It's nice that they have that chart and they can put it all out there for us. The next one is the security deposit going into paragraph 5. This kind of outlines the disposition of the security deposit, how it's adjudicated, right? The main point you always have to make sure that the landlord understands is within 45 days, they have to provide the security deposit back to the tenant, or a letter or notification as to what their security deposit deductions were, what the costs were, and then any remainder of that security deposit. Now, they do get additional time if they have to get estimates for certain things. Maybe there was a lot of damage or whatever, and they have to get additional estimates. They can notify the tenant that due to the fact that there was, the dog chewed the whatever, and I have to get estimates, which I'm having a hard time getting, and that would give the landlord an additional 30 days. So whenever you get that call from the landlords, hey Steve, I got a lot of damage from these tenants. When do I got to get the security deposit back to them? See this paragraph in your lease, whatever, paragraph 5. It kind of outlines everything for them. It's a good paragraph for them to understand, especially if you're not managing the property. If we're not managing the property, they have to be on this. Because what happens if they don't provide a letter or return the security deposit within 45 days? The landlord is, if they don't do either of those things, right? And the security deposit was being detained for damages, and this tenant takes them to court because they never received anything within 45 days, the landlord will have to refund their whole security deposit. So if they had a $3,000 security deposit and they had $3,000 worth of damage, and they didn't provide a letter to the tenant within that 45 days, and the tenant goes after his security deposit, and they go in court, and the landlord says, well, where's the letter that you sent? Where's the information that you sent the tenant regarding deductions from the security deposit? And the landlord says, I didn't send anything. I just told them I was keeping it all. Well, that's not what it says here. Give them their money back. Not going to be a very happy landlord, right? So, and then you can also, money from security deposit can be used for other things. So if during the lease term, including any extensions or holdover, any part of the security deposit is used by the landlord in accordance with the terms of the lease or applicable law, landlord will provide notification to the tenant of such use. So say I paid half of my rent, and the landlord says, hey, I'm going to use half of your security deposit, pay that rent, then you have to provide notice to that tenant that, hey, I have used half of your security deposit to pay your rent. Or other charges that you may have incurred on behalf of the tenant, right? So say the landlord has an HVAC service visit. Well, they're supposed to be there on Friday at between 10 and 2, and they're not home. And the service guy goes and knocks on the door, no one's home. He says, well, it's going to be $50 for me to come back for a missed appointment. So the guy goes back, you tell the tenant you owe $50. The tenant says, I'm not paying that $50, and you say, oh yeah, you are. I'm going to deduct it from your security deposit. You can either pay me or I'm taking it from your security deposit. So you have to provide that notice. They have to provide that notice in writing to the tenant electronically. So an email's fine, right? If they have a management company, that would be paragraph 6. Paragraph 7 is an appointment of a resident agent by a non-resident landlord. We talked about this in last week a little bit. So if your landlord is not living in Virginia, they are required by law to have an agent that is licensed and has an office in the state of Virginia. That doesn't mean we have to make them do it. We just advise them. We can lead the horse to the water, but we can't make them drink. So if they decide they don't want to hire one, we don't fill this in. If they've hired one, then we fill this in with whatever information. Okay? Of course. What would that question be? Non-resident agent?
It's always been this way, or it's recent years? I didn't realize that was that.
It's always been in there, but I think it was put into place not 2024, but 2023. July 2023.
Oh, okay.
So it's always been in there. There's always been an option for the landlord to hire a non-resident agent if they're not living in the state. However, they have changed the laws in the state now that require it.
That's why, because I don't remember advising them before.
Right.
So that if their family member is doing their rent, in
What's that?
charge, their family members doing their own rent previously, it was okay. I didn't think anything of it.
Yeah, there's nothing in regards to a non-resident. A non-resident agent is not a property manager.
Right.
It's just a point of contact for a landlord who lives somewhere other than Virginia. So that way, if something goes down with the property and the state or local jurisdiction has to get a hold of the landlord, and they're not occupying the property and they don't live in the state, then they have a way to get in contact with them, or they have someone who is acting on their behalf to mitigate whatever the issue is that needs to be taken care of.
All right, thank you.
So not only do your resident, you have to register with the SEC who your resident agent is, right? So that way, if the state will look up your property, they would see you have an agent assigned, and then they would contact the agent assigned in order to get a hold of you. No. And Samson Property says, guess what? We cannot be non-resident agents. So they don't want us acting in that behalf. Next one is fire casualty. That's pretty straightforward. Truthfulness of representation in their rental application. So we talked a little bit about this earlier. If they miss things or you find out things later on in regards to what they put in their application, it outlines in here if they have misrepresented themselves or put stuff that's untrue, then the landlord would have the right to terminate the lease, proceed to obtain possession of the premises, and seek damages and other remedies under paragraph 30 of the lease terms, right? So if you find out stuff later on in regards to this, then you could potentially use this paragraph to cancel the lease and get out. Now that doesn't really hold true for the ESA, emotional support animals, that kind of stuff, because once they tell you they have it, even if it's during the time that they have a lease, the Americans Disability Act allows that to happen. Number 10 is uses. The only thing really I highlighted here is occasional visits by guests, not to exceed 2 weeks during any consecutive 12-month period, are permitted without prior written consent of the landlord. So how many times, as a property manager, okay, how many times have you gone into a property and there's somebody there? I come in to your property and I'm rented the property to you, and then I go in there and you have your girlfriend with you, or vice versa, you have your boyfriend with you, whatever. I take a mental note of it. 2 months later, I go back there and guess what? Your girlfriend's there again. So, or whatever. And I say to you, hey, just check in, hey, I just want to verify the property is rented to you, but the last 2 or 3 times that I've come by, your girlfriend has been here. Is she living here now? Well, yes, she is. Well, according to your lease, you can have guests for 2 weeks without the landlord's consent. Over that, they need to be a part of the lease. So why is that? Because if you have to evict that person and that other person's not a party to the lease, guess what? You might have a hard time you could have a potential hard time getting that other person out because they're not really a lease holdee to your rental, your lease. So of course, yeah, hopefully they're going to leave at the same time if need be. But if they're not on the lease, there's a potential that if we evict you and you're not on the lease, then you have to go, but you could stay. And now I have to try and figure out a way to get you out, but you're not on the lease, so you're not really subject to the terms of the lease. So how do I get you out? It's a very tenuous process. So make sure your landlords understand when they go there and they rent it to one person and then they go there and there's 15 other people living in the house, right? Hey, this is not right? So make sure that your landlord understands that the only people that are available to live in the house for other than the 2-week thing we just talked about are only people that are identified in the lease unless they're the children of your leaseholders, right? So there's a place in here as we go through where you can put other occupants, but if they're minors or whatever, 18, under 18 or college students or whatever, they don't necessarily have to be in the lease because they're offspring of the people that are there. So, but just be cognizant of that fact. Somebody was raising their hand back there too. You're good? So so otherwise they should be listed in here, name of occupants, and you could list whoever additional occupants. So say you have 2 leaseholders and then you have maybe a cousin or a grandmother or whatever, however the pyramid sets up, anybody additionally living in the property, like I said, other than minors, you don't really have to list minors, but I mean, if you had an uncle living with them or you had, grandparents, sometimes you have extended families all living together, all those people should be listed. Why? Because if for any reason you had to have them removed, you want all people removed from the property. Move-in inspection is paragraph 11. Wow. Paragraph 11 is your move-in inspection. You have to do your move-in inspection within 5 days of the time period where the lease starts, right? So I normally do it with the landlord as part of the service that I'm providing to the landlord when I'm renting their property. So we'll do a walkthrough of the property, we'll denote any condition issues, and we'll provide that to the tenant when they move in. The tenant then has 5 days after they move in order to review that and add additional information. If they don't do anything, then the list that we provided to the tenant stands and we all move forward. Utilities, pretty straightforward. Fixtures, pretty straightforward there. Just make sure you fill that in. Landlord maintenance, tenant maintenance obligations, all outlined for you in the lease. What the tenant has to do, change filters, light bulbs, that kind of stuff. Statement of tenant's rights and responsibilities. We talked a little bit about that form last time. Make sure that that form is signed by all parties and attached to the lease. So another thing where if you ever have any type of court action with your tenant and your landlord isn't, say the landlord's not getting paid rent, and they go to file with the county to have these people evicted, and they don't have that statement of tenant's rights and responsibilities as part of the lease, guess what? They're going to get sent home. So make sure your landlord is protected. Make sure that we require it in the checklist, in your SkySlope checklist, it's required, so we know that it's getting signed, but make sure you do it. Lead-based paint. Of course, if the property is built prior to 1978, we have to do the lead-based paint disclosure. And then we had a great time, and in paragraph 19 is the move out. So there's a lot of questions regarding this paragraph, so I'm going to kind of talk about it a little bit. So once the tenant moves out, you have to give the tenant the option to attend the move-out inspection, and they have the right to do so. But sometime within 3 days or 72 hours, you have to do a walkthrough. Well, there's some check boxes here, right? So it says that the landlord and the tenant agree that the tenant perform all move-out cleaning and maintenance responsibilities checked below. So if you have these things, you're going to check it. We have carpet, gutters, yes. Eliminate all, yes. Install clean air filters on furnace, oh yeah. Ensure that the premises are all clean, yeah. All light bulbs are changed, yeah. So I check all these boxes, right? Or maybe I say, no, I have my own carpet cleaner. I have my own people that are going to come in and do the cleaning. I'm not going to check that box, which is box number A. So I don't check box number A, but I check everything else. It also says that the tenant's going to provide me with receipts or written evidence that the issues above have been resolved. And then underneath it says landlord and tenant agree that the landlord will perform any cleaning and maintenance responsibilities not checked above. Landlord and tenant further acknowledge and agree that the landlord will withhold X amount of dollars from the security deposit in exchange for performing these services. So say I didn't check the carpet, gutters, chimney, because I have my own guy, and it cost me $500. So I'm going to put $500 in there when we draft this lease up. So when the tenant moves out, they don't have to do A, and we're automatically going to deduct $500 from their security deposit for that service. So that's what that's for. Um, 20 insurance, then pets. If there are pets, you're going to check the appropriate box. Smoking, homeowners insurance, condo, if it is part of a condo. Here, you don't have to order the resale package for a condo or a HOA in order to provide these documents to the tenant. You can use an old set of documents and a lot that the landlord might have, or a lot of these associations now have all their stuff online. All you got to do is provide a link to the website, and then they can review all the stuff that way. Smoke and carbon monoxide. So the landlord is responsible for making sure that they have smoke detectors in the property, but the tenant can request carbon monoxide. I would highly recommend if you have a property that has gas, HVAC or gas stove, that you have your landlord install carbon monoxide detectors in the areas closest to those devices, just because it's an added level of security for your landlord to know that they're already there. And if something happens with a malfunction of either of those devices, those detectors are going to go off and hopefully save the lives of your tenants, right? Because if you don't have them, the tenants can request them, but also there could be some scrutiny as to why those weren't provided. So I always tell my landlords that I recommend that they install them, especially if they have gas appliances in their property. Early termination, paragraph 27 is early termination. If there is an early termination, this kind of goes through the process of that. And really it depends on whether the tenant is terminated because of issues in the property, that say the heat's out and the landlord hasn't fixed it and it's 20 degrees outside and they're freezing in there. So they send over a notice to the landlord saying, hey, it's been 2 weeks, you haven't fixed the furnace yet, we're evacuating the property, here's your notice. And the landlord can fix it or not fix it, and then the tenants can move out and receive their full security deposit back. So this is the early termination paragraph. Nope. Access to the premises. This outlines what the landlord can access the premises for and how that has to be established. So the tenant has to provide reasonable access to the premises in order to inspect the premises for repairs or alterations or supply necessarily agreed services. So if you have a tenant in there that's denying access, just refer them to paragraph 29. Hold on, microphone. Mr. Microphone.
What is your recommendation of inspection of a periodic inspection of a rental property by landlord? How often? Quarterly, or every 3 months, every 2 months?
Well, having been an ex-military guy, I'm not a big fan of someone coming in and trudging through my stuff anymore, as I was subject to inspections all the time. But I mean, I would say it depends on the tenant. As a property manager, I would, anytime there was maintenance going on at the property, I would go over and kind of do an informal inspection and look around. The first, I would say, I would probably schedule one the first 3 months just because I want to see how these tenants live and get a better idea of what I got in my property. After that, I probably would just do them every now and then. If everything shook out okay after like a 3-month inspection, I would just kind of do, maybe every 6 or every 9 or annual. depending on how long they stayed. But it's really an interactive process. If I had rented my property to 3 single guys just out of college, I would probably do them every 3 months. If I had a family in there and I went by 3 months and everything looked like it was in picture perfect condition, then I would probably stretch it out to a longer period of time.
Because the tenant even encourage every 3 months, even lease said every 2 months have to change the filter.
Yeah.
Even 3 months, I say, okay, remind them, still not change, 6 months.
Well, that's different. I mean, that's a whole different bag of wax, right? So if you're a landlord and you're telling your tenants to replace the filter and they're not doing it, and you know, I always recommend that landlords, one of the most expensive items in your property is your HVAC system. So I always recommended to landlords that they should at least have at a minimum HVAC service contractor go in there twice a year, one to check the heating, one to check the air conditioning. And then when they do, they always give you a printout in regards to what's going on with the system. And a lot of times in the report, you'll see HVAC filter clogged, coil dirty. So after you see that, I'll notify the tenant. I'll say, hey, according to the HVAC guy, it doesn't appear that you're replacing the air filters. You're required by the lease to do so every 2 months. If you don't do it, we're going to charge you for an HVAC cleaning the next time we get this notification. That's $350 to $450. So and we send that in writing. So it's not a conversation. It may be a conversation, and then it's followed up in writing. So then the next time when the HVAC guy goes out there, of course, they're going to slide the old filter out the day before he comes and put the new filter out in. But the guy's going to look in there and say, Steve, man, okay, yeah, it's got a brand new filter in here, but it doesn't look like it's been changed in a long time. But and then you go back and tell, you know, and that's a charge to the tenant, right? So, but you don't have to do an inspection for that, but you can. All right, continuing quickly through the rest of this. Not too much to cover here. Failure for paying rent, enforcement costs and attorneys, just to make sure that tenants and landlords understand that if they have issues and if they end up going into court, this lease has language in it that whatever party was in the wrong has to pay the legal fees of the other party. So it's good to know to each party that if they do end up in court, and it's not small claims court, of course, if they do end up in court, they could potentially not only be on the hook for whatever the issue was that they were trying to resolve, they could be on the hook for the attorney's fees. Transfer of the landlord. If you have a property that there's a potential that the landlord might want to move back into, because a lease is a right to occupy that property during the term. So if 6 months into that lease, the landlord says, I want to move back in the property, do they have the right to do so? No. They have given up that right to that tenant for the period of the lease term. Now they could buy that tenant out and provide, figure out a way to incentivize that tenant to move out. But if you had checked this box here that allows the transfer of the landlord to move back in the property, then the landlord would only have to give the required notice as set forth in this paragraph, and then they could reoccupy the property. Anytime you're dealing with State Department people in the military, those type of folks that actually this is their primary residence, and however they're moving overseas or they're moving here for a job assignment, even though they tell you they're going to be gone 3 years, who knows? A year later they could turn around and be back. So cover their behind by checking this box, so that way if they do come back, they don't have to rent a property. 32 is transfer of the tenants. So if there's service members, there's criteria set forth in here where they could vacate the property if they provide copies of their orders. There's also a box in here that you could check that allows the tenant to move if they're moving 50 miles. There it is. If they're moving 50 miles or more outside of the radius. Now that if you check that box, right, that allows them the versatility to move if they're moving 50 miles away from where their current location is, but they have to be with the same company doing the same job. So they can't take a promotion and say, oh, I work for Amazon and I got promoted and they're moving me from Herndon to Fredericksburg and I need to void this lease. Well, you applied for that promotion. They're not moving you because of the fact that you had the same job. So there is some stickler stuff in here. So if their job in Herndon got moved to, their same job got moved to Fredericksburg, well, that might accommodate this paragraph and allow them to move without major penalty. Bankruptcy, death of the tenant or death of the landlord, a lot of, and then everyone signs it and we move on. Then just quickly, I'm going to be real quick, sorry. These are some other forms that you might have that you might want to attach to your lease. There's a pet addendum. Make sure that you attach that if you, this is for pets, that's pets, right? And then there's one also if they're animal assisted, right? So if you have assisted animal that, because they're not pet addendums, so they have a separate one for those that are ESA or emotional support or service animals. So the difference really is this one doesn't have a security deposit listed in it, the other one does. And then if you are the Cracker Jack agent who's going to help your landlord do the walkthrough prior to the tenants moving in, the NVAR finally came out with a form a couple years ago, which is a move-in, move-out report, which you can use and fill in all the appropriate blocks in order to move in your tenant. And then they could, this is what could be provided to them upon move-in. Thank you for coming. You guys are the best. And if you if you have any questions related to this, feel free to bring them up now. If you have other questions, I'll stick around afterwards.